Hello and welcome. My name is Yvonne London, and I am an attorney with Texas Fair Defense Project. Today, I will be talking to you about criminal record clearing in the state of Texas, how you know you are eligible, and what criminal record clearing actually entails. Overall, it's going to be just a review of eligibility for both non-disclosures and expunctions for adult criminal records in the state of Texas. Now, before we start, it would be important for us to first explain what a criminal record actually is. A criminal record is a record of any interaction that you may have had with the criminal justice system. That includes any record of an arrest, any charge that you may have been charged with, any court appearances that you may have had in regards to that charge. All of that has a record, and that collectively is considered your criminal record. So, how do you know if you may be eligible for criminal record clearing? Um, You will know this because maybe you had an arrest that was made, but you were never charged with any offense after the arrest. Um, you may have been charged and arrested, but that case was dismissed. You may have had a case where you had completed a deferred adjudication. You may have also had an arrest where you may have completed a pretrial diversion program, and as a result of that, completing that program, the case was dismissed. There may be a situation where you have a first time and one and only misdemeanor conviction, or you may have been arrested and charged and even convicted for unlawful carrying of a weapon charge. These are all ways in which you may be eligible for record clearing in the state of Texas. Felony convictions are not eligible for any type of record clearing in Texas. Well, what is record clearing? Well, there are two ways in which a record can be what we consider cleared. That is through the expunction process or the non-disclosure process, both of which we will discuss today and explain what they are and how you may know if you are eligible for it, and ultimately what will happen if you actually apply for those types of services. We will start with expunctions. So what is an expunction? An expunction is ultimately a request and then an order that may be granted by the court, which will ultimately destroy any record of that arrest. It will completely shred it, completely destroy it, and make it as if it never existed to begin with. You can be eligible for expunctions if you had an arrest, but you were never charged with an offense after the arrest. If you were charged and that case was dismissed, if you completed a pretrial diversion or some sort of pretrial intervention program, if you were acquitted or pardoned, and now there is a relatively new law that will allow you to get unlawful carry of a weapon convictions expunged as well. Now, there is a timeline in regards to the statute of limitations for cases that you may be able to get expunged. There is a statute of limitations for most offenses. We have a list of these offenses here on the screen. You will have to wait until that date is expired before you can be eligible for expunction for your case. So for most misdemeanor cases, it's 2 years, and this is pretty much starting from the date of the offense. For other felonies, it's 3 years. But for these specific felonies, there is a longer statute of limitations. So for example, felony theft or robbery or insurance fraud, it's 5. Healthcare or debit card, credit card abuse, it's 7. Injury to a child, it's 6. And for murder and aggravated assault, sexual assault, there's actually no statute of limitations. The prosecutor has an indefinite amount of time to bring charges against you for those types of offenses. Now, the next is an order of non-disclosure. So what is an order of non-disclosure? It is basically an order that will seal the record. Unlike expunctions, it does not completely destroy the record. It just seals the record and makes it so that most entities are not able to actually view that record. However, law enforcement agencies and the court, they can still view that record. But if you were to go and apply to a job and they were to do a background check, that record will not be able to be viewed. How do you know if you are eligible? Well, you could be eligible because you may have successfully completed a deferred adjudication, and then after the completion of that community supervision for that deferred adjudication, the case gets discharged from court. Or you may have had a first-time misdemeanor conviction, or we also call that the only conviction on your record happens to be a misdemeanor conviction. You could be eligible for a non-disclosure for that as well. Now, in regards to non-disclosures, one big difference also compared to expunctions is that the court has the ability to make the determination of whether or not it is in the best interest of justice to grant the request for the non-disclosure. So the judge has some autonomy in whether or not to grant your request, whereas in an expunction, the court does not have the autonomy to grant the request. As long as you are eligible and the statute of limitations has expired, the court must grant your request. There are also some other barriers to non-disclosures. So, for example, there is a waiting period that you have to have expire before you could be eligible. And if you had a history of certain serious offenses at all on your record, that would prevent you from being eligible for a non-disclosure. So let's start with the waiting periods. So for misdemeanor offenses, there's a 2-year waiting period. And for felony offenses, there is a 5-year waiting period. Now, when does this waiting period start? The waiting period starts the day the court, the day that the case gets discharged from court. So for example, if you had a deferred adjudication and you were able to complete the probation for that time period, and the court discharges your case on January 1st, 2000, if the offense was a misdemeanor offense, you could not apply for a non-disclosure until on or after January 1st, 2002. If it was a felony offense, you could not apply for a non-disclosure until on or after January 1st, 2005. Now, during this waiting period, whether it be 2 years or 5 years, you also cannot get arrested for another offense that either results in a conviction or another deferred adjudication. As stated before, there are also a list of offenses that would make you completely ineligible to receive non-disclosures. These are those offenses. If you were ever convicted of an offense that requires you to register as a sex offender, if you had an offense that involved family violence, if there was an aggravated kidnapping, capital murder or murder, trafficking of a person, injury to a child, elderly or disabled, and the list goes on. If you have ever had any of these offenses on your record and been convicted of or received a deferred adjudication for any of these offenses, that would prevent you from being eligible for any non-disclosure for any other offense that you may have. So, for example, if you had a conviction for family violence, you could not apply for a non-disclosure for that offense. But if you also had a deferred adjudication that was successfully completed for a marijuana charge, because you have that family violence conviction on your record, you would not be eligible for that marijuana charge to be sealed. Now, there are some limitations for record clearing. First off, this is not a perfect process. It is important for us to understand that expunctions and non-disclosures, this process is not perfect. It is a state process, so the federal government can still see your expunged record or your sealed record. Furthermore, Texas state agencies that have been ordered to expunge records may not completely comply with the order, and there will have to be further action taken against them to force them to comply. There are also private internet companies that have access to your records that they may have gained that access prior to you applying for a sealing order or an expunction order. And because they are private entities that may run background searches for other requesting employers, we don't necessarily know who they are. So therefore, we cannot put them on our applications to request that they be given this order too, and that they be forced to either seal the record or destroy any access to the record. And unfortunately, courts have little, if any, control over these companies. So there's not much that we can do or that can be done if there are companies that have access to your record prior to you filing for it to be sealed or expunged. There are also immigration complications. So an expunction or a non-disclosure does not do anything for immigration purposes, and it can sometimes cause problems in your immigration case. And that's mainly because the immigration is done federally and not through the state, so the federal government does not have to comply with any of the orders that the state has regarding sealing or expunging your record. Also, when you go through the immigration process, the court wants you to be fully upfront about your criminal history. And if you have anything that may be sealed or expunged, they consider it you not being fully upfront about being arrested and charged. So it can cause some issues in regards to your immigration case. Also, if you have an open immigration case, you should get certified copies of all of the criminal case records prior to beginning the process of sealing them or expunging them. So at least you have access to it prior to it being destroyed or sealed, because once the record is destroyed or once it is sealed, it is very hard, if not impossible, to go ahead and get copies of those criminal records and then certify them. So it's good for you to start the process by getting those copies first and then proceed. So what do we use in order to tell if somebody is eligible for record clearing services? The first thing that we will need is a copy of your criminal history report that the Texas Department of Public Safety has. There is a fee of about $25.53 in order to get this particular report. And this criminal history report is what we use to see all of the offenses that you have had arrests for in the state of Texas. And we will use that in order to determine whether or not you may be eligible to receive record clearing services. You have to go ahead and request that through Identico. And we will discuss that in a little bit about how you can make that request. But once you make an appointment with Identigo and you sit for the appointment, they will go ahead and then provide you with your criminal record, your criminal history report. On top of the criminal history report, we will do searches from those respective courts that you may have had your cases heard in to get the copies of the record from the court or the district clerk. And we will use that along with your criminal history report to ultimately determine whether or not you may or may be eligible, may or may not be eligible for services. Here's a couple of copies of some criminal records. In particular, it looks like this one is a motion to dismiss. So this will be showing why the case was dismissed from court. And we will use that to help us make our determination. And also, if you are eligible, we will provide a copy of the court. We will provide a copy of this to the court and attach it with our paperwork that we file. Now, how do you get relief? Ultimately, in Texas, it is a petition-based process. It is not automatic. In Texas, there is about 6.5% of people who are eligible to get relief that successfully get their relief because they have to actually apply for these services. And not only do you actually have to file the petition with the court, there's also a fee involved for filing these petitions with the court. There is a fee of about $250 to $360 for filing a non-disclosure or a expunction with the court prior to you even going further and seeing if the court is going to grant this and starting the process. That's how much it costs to actually file. But for Texas Fair Defense Project clients, we provide pro bono services to individuals who cannot afford legal services. They would be considered indigent by the terms of the court. If you are in a position where you would be considered indigent, you could provide this form to the court. It's called a statement of inability to afford court costs. And we will be able to help you fill out this information based on your current financial picture. And you would be able to get those court costs waived. So there would be no filing fee for beginning this process. So what is next? Now, if you believe that you had a case that would be eligible for record clearing services, this is a list of eligibility. If you had an arrest that was made but you were never charged, an arrest that you were charged for and the case was dismissed, the deferred adjudication, all of these things would make you eligible. If you believe that any of these things applies to you, you could apply for our services. The first thing that you would have to do is get a copy of your DPS criminal history report. So you would have to make an appointment with Identigo. This is the link for where you can go ahead and make that appointment, get fingerprinted and pay the fee. Then you will receive your criminal history report. Once you receive that report, you can then apply online on our website for our criminal record clearing services and upload your DPS criminal history report along with that application, and we could begin the process. Now, if you are viewing this video at one of our clinics, we will be able to assist you with getting the criminal history report appointment with Identigo at our clinic. We will also be able to assist you with our online application at our clinic as well. However, if you are viewing this and you are not at the clinic, we have included the links for you to go to either DPS, for the Identigo, to do the Identigo appointment, or you can go ahead and also click on that link to get connected to our website so that you can go ahead and fill out our application. Now, once we receive the online application that is complete, and a completed online application also includes the CHR. So once we receive both, we will then begin the process of determining your eligibility. That means we will review the CHR, we will contact the courts to get copies of the records and make our determinations that way. And you will be contacted either way, either telling you that you are deemed eligible and then what the next steps are regarding your court appearances and filing the paperwork, Or if you are not eligible, you will be given a detailed explanation as to why we cannot assist you. So this is my contact information, and down below is also the link to our website that contains information on all of the services that we provide, including our record clearing services. And this is a link to our QR code that will bring you directly to our online application for record clearing. I hope that you all found this information to be very helpful today, and I hope that we can possibly assist you on this journey of possibly clearing your record. Have a wonderful day.